Hi, I'm Rodney Rouzan with Ward Wars 101. We're going to start off today and we're going to talk about the clause that the trustees that they ignored. Every case has a turning point. For me, it started with a single paragraph buried in the family trust, a few lines that changed the entire outcome of the court case. This is what happens when words decide who holds the power. Before the case ever reached court, we had already filed written objections directly with the trustees. They had violated the trust over 40 times, using funds for personal expenses, ignoring accounting requirements, and refusing to answer basic questions. My mother, as a beneficiary, was being ignored and bullied. She asked me to step in as her attorney-in-fact to protect her rights. Once I stepped in, I documented every violation and demanded correction. Instead of addressing the objections, the trustees spent more trust money to take the matter into probate court, an action that itself violated the trust. After they forced the matter into court, we filed a formal objection to the petition inside the probate case. The court reviewed everything and issued 11 separate probate notes, 11 issues that had to be cleared before the case could even move forward. As my mother and I researched the trust more deeply, we discovered the provision that controlled all of this, the Special Co-Trustee clause. That discovery proved that the trustee's entire filing lacked jurisdiction from the court. Article 3.7, subsection H, stated clearly that no one may file or instigate a claim in the court without first submitting the matter to the Special Co-Trustee for resolution. That clause wasn't just technical, it's defined who had authority. Because trustees ignored it, the court never legally had jurisdiction to hear the case. Law isn't just about arguments, it's about the sequence. We acted first under the trust, within its own process. They skipped the process and tried to use the court to legitimize their violations. Once they did, their own actions became evidence of the breach of their bad faith. We filed a motion under Probate Code 17200 to dismiss for lack of jurisdiction. Our position was simple. The trust governs first, the court second. When you file based on the principle, statute, and written record, truth doesn't need a motion. It shows itself in the paperwork. A few weeks later, the trustee's own attorney dismissed the petition. After spending over $15,000 of the trust money on unauthorized filing, they had no choice but to back out. The same system that opened the door quietly closed it. Since then, I've heard from many other families in trust disputes facing the same pattern. When trustees control all the money, they often weaponize it, using the trust's own assets to hire attorneys and defend themselves against the very beneficiaries they're supposed to serve. That's exactly what my aunties were doing here, turning the trust money into their shield while burning through everyone else's inheritance to cover their tracks. It's a painful truth, but it's one people need to see. This case reminded me of the power hides in procedure. When you understand the structure, who has authority, and where it begins, you can stand your ground even when others misuse their authority. Most people never read their trust, and that's how mistakes and manipulation continue unchecked. In the end, the words did the work. They drew the line between the authority and overreach. And that's the lesson. Read the document before it reads you. Follow War Wars 101 for more lessons like this, drawn from real filings, real hearings, and words that decide them. Thank you.
Words in papers, words in books, words on TV, words for books, words of comfort, words of ease, words to make the fighting cease. Eat your words, but don't go hungry. Words have always nearly hung me. Words are stupid, words are fun. Words can put you on the run. Concrete words, abstract words, words to tell you what to do. Words can put you on the run.